Hello, everyone. My name is Giovanni Nogales, and I'm a paralegal here at Laos Parker. Thank you for joining us for this new webinar series with the Home Care Association of Louisiana. Today's webinar is entitled Buying and Selling Home Health and/or Hospice Agencies. Our presenter today is Jennifer Papapanagiotou. Jennifer focuses on compliance, regulatory, and transactional matters for a wide array of healthcare providers, including home health and hospice agencies. She has extensive experience in analyzing proposed and existing business arrangements for compliance with federal and state fraud and abuse laws and drafting a wide variety of legal agreements. Ms. Papapanagiotou is knowledgeable in all aspects of state licensing for home health and hospice providers, and in Medicare and Medicaid enrollment, including initial enrollment, changes of ownership, and appeals of revocation actions. Finally, she assists clients with compliance plans, forming new businesses, and addressing Medicare and Medicaid program coverage and reimbursement issues. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box, and we will address as many as possible at the end of the presentation. So without further ado, I present to you your speaker, Jennifer Papapanagiotou.
Thanks, Gio. Let's go ahead and go to the first slide here. And a little disclaimer, I'm usually joined when I do this presentation by my colleague, Heidi Kocher. She's not able to be with us today. She had something come up. So I will be flying solo today. And I appreciate everybody tuning in to listen during, I hope, your lunch hour. So today we're going to talk a little bit about merger and acquisition trends. We'll go through some transaction basics, sort of some overarching observations that I have on this type of transaction. We'll talk a little bit about applicable health laws, including the Stark Law and the Anti-Kickback Statute that influence how transactions are structured sometimes. We'll go through the important steps and documents in a transaction, various post-closing issues, and then some special considerations we have in home health and hospice. So let's go to our first slide. So I update this every time I do this presentation because things change always in healthcare. But one of the constants we've had since probably beginning of 2022 is that pandemic-related enforcement and audits are heavily on the upswing right now, whether those are specifically focused on pandemic funding programs like PPP loans or provider relief funds or SBA disaster loans, or on claims for telehealth services or anything and everything related to the pandemic. We are seeing a lot of auditing, either by UPICs or sometimes by the federal Department of Justice, local AUSAs, and they tend to be more involved in pandemic-related enforcement along with the Office of Inspector General. That can influence, and certainly when we do transactions, we do see buyers asking lots and lots of questions about a seller's compliance with the various programs if they participated in any of those pandemic programs. This was fairly new. We were just notified several months ago that Medicare is going to start imposing enhanced oversight on hospices that undergo asset sales or 100% changes in equity owners. I'll talk a little bit more about that later on. Right now, it's only applicable in Arizona, California, Nevada, and Texas. So if you were looking to expand into hospice in one of those states, that's certainly something you would want to be aware of. That's a very new thing. The other interesting new proposed rule that was released very recently is that CMS is proposing to extend what we call the 36-month rule that currently exists in home health to hospices. This is to curtail what they call churning hospice certifications, where people go out and simply get a license, get a hospice accredited, get its Medicare certification set up, and then they immediately flip it and sell it to someone else to run. CMS doesn't like that. They feel like owners that come to own a hospice without having gone through that certification process and just sort of flipping it with little to no patient volume is questionable. So they have proposed to extend it. And I would expect that rule to be finalized when they finalize all the payment regulations at the end of this year. As I've said under the first bullet with enforcement activity, integrity auditors, including the UPICs, are still very, very active in all things home health and hospice. We are seeing more suspensions and revocations along with overpayment demands than we have over the last several years. Obviously, activity was low to non-existent during 2020, and it was pretty slow in 2021, but since the beginning of 2022, things have very much picked up. So let's go to the next slide. Just some sort of overarching observations on transactions before we kind of get down to the nitty gritty. First and foremost, I always have to set expectations with clients, whether you're a seller or a buyer, that transactions can take time to complete. You have to be methodical, whether you're on one side or the other of the deal, and regulatory factors can influence how long a transaction takes. If your particular transaction requires, or for example, advanced filing of a license application, then you have to build that into your timeline. I very much encourage buyers not to skimp on due diligence. Take your time, be methodical. If you structure things correctly and everybody's on the same page and you set expectations through something like a letter of intent on what timeline looks like, then everybody will have a much more successful process in the long run. We're seeing, every month, every year, increased cost and complexity to run these types of businesses, and there's just a ton of enforcement risks. So I am seeing lots and lots of small, either single hospice agencies, home health agencies, or small organizations with maybe a handful of locations looking to sell to larger companies just to mitigate their risk. And, it can be very, very difficult for a small organization to keep a pace and educated on all of the compliance issues and regulations that these particular industries are required to comply with. And a lot of people at smaller organizations are ready to get their money out and move on to something different, perhaps retire. So I'm still seeing a ton of activity in smaller organizations being gobbled up by bigger organizations, whether that's private equity or regional organizations with just more volume that are looking to consolidate or expand their service area by acquisition. I highly, highly, highly recommend that if you're either buying or selling, that you don't just hire a lawyer, but you hire a healthcare lawyer. Healthcare is a very unique area with a lot of unique laws and regulations that you need to be aware of. And even if you've got a favorite mergers and acquisitions attorney that you may have worked with on corporate issues, it's certainly, fine and dandy to hire that person to help, but you're gonna want to at least get a healthcare person on board to consult with, so that if they can advise you on anything that's unique to the healthcare area that might affect that transaction. We do advise and encourage people to talk to accountants and valuation experts to advise on the status of assets or entities being acquired, to help understand what your business is worth. That's not what lawyers do, that's what financial people do. And so you always need to have sort of those folks on your side to help you either evaluate a sale or to competitively and accurately price a buyout offer. So let's go to the next slide. The first bullet is, it's simple but very important, and that is do your homework and don't be afraid to walk away. And this applies to both buyers and sellers. Buyers, obviously, you've got to go through a due diligence process, learn everything you can about the target that you're looking to acquire. I've talked to too many buyers who didn't do this and ended up what they bought was not what they thought it was, or it had some potential liabilities it wasn't aware of. And usually it's because they rushed through a deal because they just thought it was too good to be true and they didn't want to lose the opportunity. In my experience, if it looks too good to be true, it probably is. There's a reason. And if you have counsel help you evaluate that target, look for liabilities, do some digging, it really helps mitigate some of that risk. I see lots of deals that get to the letter of intent stage where a buyer has put in writing a proposal to buy a business, and for whatever reason, they never close, either because the buyer has financing problems or something comes up during the due diligence process that changes the economics of the deal to such an extent that either the buyer or the seller aren't willing to move forward. And sometimes people just change their minds. It certainly happens, and there's not necessarily a business risk related reason for that. They just simply decide they're not ready to proceed. Every deal is different, and every buyer and seller is different, but the deals themselves generally have the same or similar documents and processes. About 70 to 80% of the transactional documents are standardized and can apply across lots of different industry types. That's why, you know, a regular corporate or mergers and acquisitions type lawyer could draft you an asset purchase agreement or a stock purchase agreement. But there's about 20 to 30% of any transaction involving a healthcare business that is going to be unique. You're going to have unique representations and warranties. You're going to have unique indemnification risks. And, you know, your regular mergers and acquisitions guy who's never worked in healthcare may or may not be sensitive to those and aware of those, or have the kind of language that I see in transactional documents every day and I help draft or help review. So as I said before, healthcare transactions are a little more specialized. There are a lot of regulatory issues we have to think about. So it's important that you've got somebody on your team that understands those. So let's go to the next slide. All right. We'll get a little bit more into the process for a transaction and the different documentation, the pieces of documentation and what's in those. So you have kind of a feel for what a transaction looks like. Most deals, not all, but most start with something called a letter of intent. It's not a mandatory document by any stretch, but what it generally is intended to sort of lay the groundwork for a transaction and show that the parties are on the same page with the big things, the big terms. We'll talk a little bit more about that. The second step is typically due diligence, where the buyer is going to ask a whole bunch of questions about the business and expect the seller to be transparent and forthcoming with information. These are all obviously done with promises of confidentiality between the parties so that anything that's shared during due diligence remains confidential. The next step would be a purchase agreement. This is the definitive document, and it'll include all the important terms you need to see in something like that. Purchase price, including any holdback escrows or earnout or other post-closing transactional terms, representations and warranties, indemnification promises, exceptions and limits to indemnification, and it'll identify any sort of ancillary closing documents that get signed at the same time. And then finally, once all that stuff's drafted and all the other checkboxes have been addressed, you'll get to closing, where hopefully money changes hands and legal ownership of either the assets or the stock in the company changes hands. Let's go to the next slide. So I'm going to sound like a broken record, but before you draft and sign something like a letter of intent or a purchase agreement, you really need to consult with an attorney. I beg of you, please, an attorney that has experience with transactions, even if it's a generalist. Don't do this on your own without any legal counsel. It's worth the investment. If you can get someone on board with healthcare experience, all the better. I've certainly seen folks DIY deals where a buyer, sends a seller a simple stock purchase agreement or asset purchase agreement they found on the internet, and they change some names and change some terms, and everybody signs it. And my experience with deals like that is that they often create more problems than they solve, and we end up having to go back and fix things because something has happened, or they don't include terms that are intended to protect both buyers and sellers in a healthcare specific transaction. And a buyer is either left holding some liability it never intended to get, or a seller's promised something they never should have promised. So again, highly recommend you consult with counsel. Something to be aware of, federal and sometimes state laws can impact the terms and timing of a healthcare transaction. That's something a healthcare attorney can advise you on. Your attorney can also outline limitations in purchase price, financing, those periods, and other key terms. And for example, some of these laws that can affect the structure of a transaction include, for example, if a buyer is going to pay a seller over time, depending on what kind of business it is, the healthcare fraud and abuse laws may limit how long that payout period can be. So let's go to the next slide. We'll talk a little bit more in depth about these laws that can apply. The first one is the Stark Law, which is a federal civil law. It prohibits a physician from referring patients for designated health services to an entity with which the physician or his immediate family have a financial relationship, unless an exception applies. Bunch of key words in here and a bunch of things to take note of. One, this only applies to physicians, not to other types of healthcare providers. It only applies if designated health services are involved. Fortunately, hospice is not a designated health service, but home health is. And it requires that there's some kind of financial relationship between the physician making the referral or his immediate family and the entity to which he's making that referral. This law is important in home health. It affects things like whether physicians can even invest in home health services. And the short answer to that is, for the most part, they can't unless they never make a referral to that home health agency. There is a very limited exception for physician investors in rural home health companies, but I think in 25 years, I've seen one example of a physician who's actually an investor in a rural home health agency who is also a source of referrals to that agency. It is sort of uncommon to see physician ownership in home health, so the Stark Law doesn't have a lot of impact on home health and hospice deals for the most part. I bring it up because it is something we have to be aware of, but it isn't very common that we have to worry about it. For that reason, I'm not going to spend a ton of time talking about Stark because I do want to talk about anti-kickback. But an example of how this might apply is Stark might apply if a seller is physician owned. So if a home health agency had a physician investor and that physician will ever refer a Medicare patient to the buyer of that home health agency. Again, it's very rare, but we have to at least point it out. Stark is a strict liability civil statute. The penalties for violating that law include loss of any of the tainted referrals and possible fines or penalties on top of that. So let's go to the next slide. There are exceptions under Stark if you do find yourself having to comply with this law for what are called isolated transactions. I'm not going to spend a lot of time on this because, again, as I said, it's rare that this applies. Let's go to the next slide. The anti-kickback statute is a federal criminal statute. The violations can carry very significant penalties, financial and jail time. So it's important that we make sure we're complying. It prohibits the knowing and willful exchange of anything of value to induce or arrange for referrals payable by Medicare or Medicaid. It doesn't limit who can make those referrals, and the term referral has been very broadly interpreted by both the HHS Office of Inspector General, which oversees compliance with this, the anti-kickback statute, and through court decisions in the federal court system. Transactions among parties who refer to each other are subject to the anti-kickback statute. This comes into play sometimes where we have a transaction between a seller who maybe is an owner-operated type business where the owners are actually actively participating in the business. They're going to sell out to a buyer, and the buyer wants those one or more of those owners to stay on with the business. And depending on what kind of role they'll be in, then it can influence how we structure a transaction. It can also impact transactions where a seller may have multiple businesses that could potentially generate referrals to the buyer. And we need to be sensitive to how we structure a transaction in that situation. So let's go to the next slide. Under the anti-kickback statute, we have something called regulatory safe harbors, and these are specific situations that have been defined by statute. And if you meet every requirement of these safe harbors for a, whichever one applies to your particular arrangement, then you can be protected, and your deal is protected from potential liability under the anti-kickback statute. As you might imagine, those safe harbors are very, very rigorous. It can be very difficult to meet every element of one, and unfortunately, we do not have a safe harbor that protects the kind of transactions that involve home health and hospice agencies. The good news is that failing to fit within a safe harbor does not mean that your arrangement violates the anti-kickback statute. It just means that if a regulator was ever to look at it, they would look at all the facts to determine what the party's intent was. We do have a safe harbor that comes close, and for that reason, we pay attention to that safe harbor when we're structuring transactions, and we try to come as close to it as we can if we think there's risk associated with that particular transaction. Sometimes we're not worried about anti-kickback because we don't see risk, because we don't see referrals after closing potentially flowing from, say, a seller to a buyer. But it does come up in some situations, and for that reason, I kind of gave you a go-by here of what that sale of practice safe harbor, which is really intended to apply to transactions between practitioners, so physicians generally, and between physicians and hospitals. And if you meet every element of this safe harbor, then that transaction would be protected. This came up in the era when hospitals were out buying up physician practices, and obviously the physicians had to stay around after that kind of transaction happened. So the Office of Inspector General created this safe harbor to allow those deals to happen, but to also put some restrictions on them so that they didn't become abusive and it didn't become a way for hospitals to just pay physicians for referrals. The most important element of this is it puts a time limit on completing a transaction and on referrals post-sale between the buyer and seller. It essentially can limit how long a buyer can take to pay a seller, so that you're not, sort of dragging out for 5 years some payment arrangement between a buyer and a seller that presents that opportunity to reward referrals or retention of business that otherwise, wouldn't really look like an arm's length transaction between two people who didn't refer to each other. It's a complicated safe harbor. I don't often see this become a huge issue. Every deal is different, and it's unusual, honestly, in home health and hospice. We do see sellers sometimes stick around to help with transition for a period of time between a seller and a buyer. And sometimes we see buyers hiring a seller owner to serve in some role after closing. And we have to sort of navigate those as they come up and make sure that both the structure of the transaction itself and the structure of whatever arrangement that buyer wants with a seller owner is compliant. So let's go to the next slide. If a deal, like I said, if a deal doesn't fit in a safe harbor for some reason, then it can be useful and protective for buyers and sellers to get an advice letter or a risk analysis from their attorney, just to give them some assurance that they've structured to be as compliant as possible. And if fair market value is an issue in a transaction, we often recommend appraisers to third-party appraisers who are experts in valuation to help support whatever the transactional price is. And again, your application of these two things, either a risk advice letter or use of an appraiser, can vary widely. And honestly, I don't see either of these a whole lot in home health and hospice deals, but it can come up from time to time. Let's go to the next slide.
Hello, Jennifer?
Terms and opens the conversation for further negotiation. Letters of intent, generally speaking, are non-binding, except for the non-disclosure or confidentiality provisions, and generally exclusivity provisions, meaning once everybody, a buyer and a seller, have signed that letter of intent, generally the buyer wants the seller to agree they won't talk to anybody else about selling the agency for a period of time. And that can range anywhere from as short as 30 days to as long as 90 or 120 days, depending on how long they think it's going to take to get through things like due diligence and get transactional documents drafted. The LOI is important. It sets the tone for coming negotiations. It's important that if you are going to sign a letter of intent, that it's well drafted. We want them to be as clear as possible. And there's certainly important terms that sometimes sellers don't think about, and buyers may either unintentionally or intentionally not bring up in a letter of intent. So an experienced healthcare attorney that's representing a seller or a buyer can help guide sort of what are the important things to document in that letter of intent. Are there any financial terms that seem to have been overlooked that we really should talk about now because they could become big deals later on? I'd like to get the big deal terms into the letter of intent so that we're not trying to solve something like whether you're going to agree to a non-compete or whether you're going to provide working capital for the buyer or how you're going to split accounts receivable. Those are big deal terms that need to be discussed probably before you sign a letter of intent. Let's go to the next slide. So once you've got that letter of intent and everybody's happy with it and everybody's signed, we generally move into the due diligence phase. This is sort of the caveat emptor phase. Buyer, educate yourself and be familiar with what you're buying. Both parties sometimes do some due diligence. Buyers tend to do a whole lot more than sellers, but you're doing that to ensure that the business or ownership interests that are being purchased are what the buyer thinks they are. And you're looking to identify liabilities and risks associated with those either assets or equity interests. Buyers are going to want to look at everything from financial statements to tax returns, and they're going to want to look at your clinical operations, your business operations, all of your regulatory compliance documents, licenses, certifications, surveys, etc. They're going to want to examine personnel information. How many employees do you have? What kind of benefit programs do you have? Are you compliant in those benefit programs? And are you compliant in your employment practices and policies? And they're going to really dig on all aspects of the business to understand what they're buying. And it's an important part of any transaction. I have represented a ton of sellers over the last 4 years, and this is the biggest part of a transaction for sellers. They spend a lot of time organizing and digging for this information to provide to a buyer. It's work, but it's valuable work, and it's important to help the buyer learn about your business. And frankly, you have to do it to get to the finish line, which is closing. So the more organized you can be in the due diligence process, and if you're thinking of selling a business, I often talk to sellers way before they get to even putting their business up for sale, and tell them these are the things you need to start getting together now and organizing and making sure they're in good shape. So we can kind of stage your business for a potential sale and make that due diligence process a little bit easier. Let's go to the next slide. I think any buyer should do a mini claim audit and really evaluate documentation of a seller organization. Sometimes those can be done by outside consultants. Sometimes they can be done by your healthcare attorney or their firm if you find someone with experience doing that kind of work. Certainly our firm has that expertise. Engage an expert if you think it's necessary to help you understand what you're buying and to evaluate things like documentation. Really, the single biggest risk in any healthcare transaction is the risk of overpayment liability or future investigation of services that were provided before the transaction was completed. So that we call the closing date is sort of, the date when it changes ownership. And a buyer, because they generally take on the Medicare and Medicaid successor liability, they take Medicare and Medicaid provider numbers. They also take all the Medicare and Medicaid liability going back as far as Medicare can go, which on the administrative audit side is up to 4 years, and on the False Claims Act and some of the other statutes, it can be much longer than that. So it's real important that buyers evaluate documentation and look for risk areas, and it can affect purchase price if things don't look great. So it's something to both prepare for as a seller and do a thorough job of as a buyer. Let's go ahead and go to the next slide. So the next big document, and this usually comes sort of towards the end of due diligence, is actually the purchase agreement. This is the definitive agreement for the transaction. This is the legal document that sets out all the terms for the transaction, and it's gonna specify price and how that purchase price is paid. It's gonna document the risk allocations in both reps and warranties and indemnification provisions and all the other material provisions of the transaction. So it's the basis for all your legal rights regarding closing, payment, penalties, liability exposure after the transaction happens. So it's really important that it's well crafted and that you understand the document. I go through, when I represent sellers, we spend a significant amount of time walking through the different terms in the transactional document because they're generally drafted by the buyer's attorney, and making sure that what's written down in that document matches the deal they expect, that it fits their understanding of what the deal is, and that they understand all of the different terms of that document so they know what they're getting themselves into as a seller. You know, sellers are often asked to provide indemnification for pre-closing liabilities. Well, it's important you understand what that means, and that we try to put some guardrails around it if I'm representing a seller. So it's very, very important, again, that purchase agreement reflects your full and final intentions regarding the purchase or sale of the target business. So let's go ahead and go to the next slide. There are really three sort of general types of transactions. Really, the first two are the most common in home health and hospice. The first is an asset sale, and this is where a buyer is buying certain identified assets, property, or liabilities of the seller, but they're not buying the company itself. They're not buying the seller's equity. In an asset sale, the buyer forms usually a new entity, or it uses an existing entity to buy the assets of the seller business. And after closing, the new owner of those assets and the Medicare PTAN usually transitions over, because that's what buyers want. But it'll be under that new buyer's legal entity and their new EIN after closing. That's an asset sale. In an equity sale, the buyer is buying the seller's equity interest in the provider entity. So they're buying either stock or LLC membership interest from the individual who owns it or the company that owns it. And therefore, they're acquiring the entire business and all of its liabilities. And if, from a regulator's perspective, the same entity owns the business before and after closing, it just has different either shareholders or members, depending on whether it's a corporation or an LLC. So equity sales are simpler in healthcare because they generally don't require the same kinds of license applications and advance notice and consents for things like assignment of contracts. But they certainly increase and ratchet up the risk to a buyer because the buyer is kind of taking that business with all its problems. The due diligence on equity sales tends to be more intense because they really want to dig deep to understand what potential liabilities are. So, but again, the pros of an equity sale, the positives of it are that it can be much easier to navigate the regulatory side of things. So buyers really have to weigh whether they want to do an asset sale or an equity sale, and I've certainly done lots and lots of both over the last 25 years. So the final form is a merger where two companies come together to form either an entirely new entity or one merges into another. Don't see a lot of these in the home health and hospice area unless, you know, you may see this with publicly traded companies or really huge organizations, but it's fairly unusual in smaller transactions. Let's go to the next slide. Sort of unique healthcare issues in these different transaction types. In an asset sale, home health and hospice agencies generally have very few what we call hard assets, tangible things, furniture, equipment, things like that. Most of the value in a home health or hospice business is goodwill. It can be that there are also accounts receivable or other what we call intangibles that are transitioning between the parties, but most value is usually in the goodwill. Generally, the buyer does take assignment of the Medicare and or Medicaid billing numbers if the state allows that for Medicaid, but few other liabilities transition in an asset sale from the seller to the buyer. I see these a lot where a seller has sort of non-healthcare related debts, tax obligations, or some other loans or liabilities that the seller doesn't want. Or where a buyer either doesn't want the Medicare or Medicaid numbers, or the buyer's just risk averse for whatever reason. Could be there's pending litigation and they don't want to be, they want to carve that out. And so they want to do an asset sale instead of an equity or membership interest purchase. In the second type of transaction, the stock or membership interest sale, that equity deal, then the legal entity owning the home health or hospice agency does not change, only the shareholders and members do. The buyer agrees to accept assignment of Medicare and Medicaid provider agreements along with contract, tax, and all other company liabilities. So in these deals, if the seller entity has liabilities that the parties are going to negotiate whether those liabilities get paid off as part of the closing and maybe out of purchase funds. So generally speaking, buyers want entities to be debt-free and liability-free when they buy them. So I have seen buyers negotiate in to take on certain liabilities in a stock or equity interest sale, but those affect purchase price. And so, every deal is unique, like I said. Sometimes they can navigate, a liability and still do an equity sale because it's so much simpler from a regulatory perspective. But again, it can affect or impact purchase price. Mergers, successor liability really depends on the structure of the transaction. I don't want to spend a lot of time talking about it because it's fairly uncommon these days. Let's go to the next slide. Purchase price structures can kind of vary widely in deals, but it's pretty typical for buyers to want some portion of purchase funds to be held back at closing to cover potential liabilities for a period of time, because we have such high audit risk in home health and hospice. They want to preserve some portion of purchase funds, generally in an escrow account, to protect and sort of pay off any pre-closing liabilities that might pop up after closing. These holdbacks, that's a general term we use, sometimes they're called escrows, can range from 10 to 25% of total purchase price, depending on the risks associated with the seller's business. And the holdback periods can vary widely. It can be as short as 6 months, it could be as long as 36 or even 48 months, depending on the risks associated with the seller business. I always encourage parties, especially sellers, to consider formal escrow accounts and agreements. This is protection for the seller and ensures the money to pay a holdback is there when the time to pay comes around. Some sellers are willing to owner finance a deal and allow the buyer to pay down the payment with structured payments over time as an alternative to a holdback arrangement. That's another structure I see. Sometimes you see both. Sometimes you see a partially owner finance deal and a holdback. I've certainly seen those. So again, structure can vary widely depending on the particular buyer and the particular seller and what the parties are willing to agree to. Purchase price adjustments at closing are common to either pay off debts of a seller, to pay transaction costs of the seller, or to provide working capital for a buyer. Those terms may sound foreign to you right now if you've never been through this process, but again, good healthcare counsel, good transactional counsel can help you understand what all that means. Let's go to the next slide. The next and most important part of any transactional document are the representations and warranties. And these are made by both buyers and sellers, but certainly sellers make a whole lot more. And these are their representations that a seller makes that confirm that certain statements or conditions about the business are true. And they also identify exceptions to those statements. So it could be anything from a statement that says, seller, to the best of their knowledge, there's no pending litigation against the company. That's an oversimplification, but that's an example of a representation. And you're also warranting, in addition to making that statement, that what you're saying is true as of the time you make the statement. If, for example, there is some pending litigation, against a seller entity, then you would add an exception.
Jennifer, I think you got cut off again. It looks like we're just having some technical difficulties. We'll see if Jennifer can hop back on. Give us a couple minutes.
Gio, can you hear me now?
Yeah, I can hear you now.
I'm so sorry. I don't know what happened. I think my internet connectivity blipped out there for a minute or two.
Wait.
Apologies to everybody. So we were talking about representations and warranties, and that these are intended for sellers to make certain statements about the business and then identifying any exceptions to those statements. It can have, we cover a host of topics here in representations and warranties, some of which are general, that you own all the assets of the business without any liens or other liabilities against them. And some of them are very specific to healthcare. For example, in home health transactions, there'll be reps and warranties about the 36-month rule. It basically says there hasn't been a change in majority ownership of the business in the last 36 months. So if there were a material inaccuracy in a representation or warranty, it could be grounds for a buyer to sue or seek indemnification from the seller if that inaccuracy caused damage or caused the buyer to suffer some financial liability. Again, as I said, common examples include things like that your financial reports are accurate and complete, there's no litigation or audits pending, and that the business has complied with all applicable law. Let's go to the next slide. So again, here's some examples of specific unique healthcare reps and warranties, things like seller has all licenses, certifications, and contracts necessary to operate, and they are current and in good standing. Sellers enrolled in Medicare, Medicaid, and those enrollments are active and in good standing. Sellers owners are not subject to disciplinary or corrective actions or appeals. Sellers conducted exclusion screening. There are no claims, enforcement of their actions, administrative proceedings, audits, or investigations pending. If there are audits or investigations pending, then the seller's job is to identify those on a disclosure schedule, and generally buyers will want lots and lots of information about what those are about. And you can expect that if it's substantive and material, then the buyer's going to want some provision for that. They're going to want some escrow holdback to protect against. Okay, Gio, can you hear me again?
Yes.
So sorry, I don't know what's going on with the internet. Can you please go to the next slide? All right, indemnification is the next big area of a transactional purchase agreement that sellers and buyers negotiate. Indemnification is usually intended to protect the buyer from liabilities that the seller may have or that may exist for pre-closing time periods. And essentially, in an indemnification provision, the seller agrees to compensate and hold harmless the buyer for any problems that arise in the business as a result of the seller's actions. They also extend to things like breaches of representations and warranties and claims by third parties that relate to pre-sale periods. Generally, this is also where we talk about how long this indemnification obligation for a seller is going to last. And as a seller's attorney, I'm often spend quite a bit of time trying to limit how long a seller is going to provide this indemnification protection. For buyers, obviously, you'd love for it to be indefinitely, so that if there's ever anything that comes up that might relate back to pre-closing time periods, you've got protection. Generally speaking, you're not going to get unlimited, except in some very limited circumstances. But this is always a heavily negotiated part of the transactional document, because it really is how we allocate risk and how we decide who's going to offer protection and how much protection is a buyer going to get from a seller. So let's go to the next step. Qualification exceptions sort of limit indemnification or put some guardrails around it. It's basically anything that might limit a party's liability. It could be a cap or a minimum amount, what we call a basket, before indemnification kicks in, or it could be a disclaimer or a revision of certain reps and warranties. Qualifications and exceptions can be, for example, something like, seller's liability will be capped at the total purchase price, except for certain, like fraud as an exemption. It could be that it's what we call a basket, where a seller doesn't have to provide indemnification until a potential claim or a set of claims reaches a minimum dollar amount. Could be something like $10,000. So a buyer's got to save up all of their potential indemnification claims until they reach $10,000, and then they can make a claim to the seller, and they can get protection from the first dollar for that entire $10,000. But they don't want the buyer coming back and nickel and diming the seller for small things. Those are pretty common in transactions. We often see a materiality qualifier. It, sort of requires an indemnification claim to relate to something material.
You're cutting off again, Jennifer.
Okay, Gio, I dropped one more time here. Qualifications and exceptions are very, very negotiable. So something a good healthcare attorney or transactional counsel can help you navigate. Let's go to the next slide. So closing is the finish line for any deal. Sometimes it occurs on the same day the purchase agreement is signed, and sometimes it happens later, sort of like if you've ever bought a house. Generally you sign a contract for sale, and then 45 or 60 days later you close on the purchase. Really depends on the structure of the transaction. Generally in an asset sale, you're going to see a purchase agreement get signed early with conditions for closing that are contingent on getting various consents to close the transaction. So legal ownership doesn't happen until you close, but the parties can sign a purchase agreement in advance that says, here's all the things we've agreed to, and we've agreed that we've got to meet certain conditions to actually close this transaction before the buyer's going to pay money and the seller's going to transfer ownership. So that's pretty common in asset deals. Equity deals, it just depends on the transaction and what the regulatory requirements are. But equity deals, it's not uncommon for us to sign and close on the same day. Let's go to the next slide. At closing, all the parties are going to review all the relevant documents, make sure that they are exactly what they expect, and they're going to officially transfer ownership of assets or equity interests in the business, and they're going to transfer purchase funds or deposit escrow funds with an escrow agent. Let's go to the next slide. So after the closing, it's generally pretty common for the parties to have to be in communication and work together to kind of tie up loose ends after closing. Many buyers want a transition period where the seller or sellers, some portion of their staff, or maybe an owner operator stays on for some period. This can help in retaining employees and patients. It also can help the buyer integrate that seller business into their current systems. You know, the owner operator especially has spent generally many years running the business. They know how to find everything, and they know the staff very well and can help with sort of smooth that transition. The goal of a seller in this situation is to minimize its exposure to liabilities from claims made by the buyer. A seller who sticks around to help transition can just help make sure things go smoothly, and that if there are concerns or issues that come up, they get solved so they don't result in indemnification claims. The buyer, however, is now running the business with all its challenges, and if issues arise that the seller should have disclosed or for which the seller should be responsible, then the buyer may have to seek a legal remedy. Usually that starts with communication between the buyer and seller over what they think the issue is, sort of a notice of indemnification, and then the parties try to work together to solve that. We try to avoid litigation. That's why we build into the indemnification provisions, we have a claim process. It's to try to keep the parties out of court or out of any kind of dispute resolution, to create a process that the parties can work through to try to solve any kind of post-closing concerns together without resorting to litigation. Keep in mind that some transactions have deferred payments. There are lots and lots of different varieties of this, and the buyer and seller often have to rely on each other to comply with those deferred payment obligations and reporting. This often happens when we have accounts receivable that change hands between buyers and sellers, or between sellers and buyers. There's going to be a period of time where you're still collecting accounts receivable after closing. They may flow to a particular bank account that after closing is controlled by a buyer, and the parties have to work together to reconcile those and make sure the money ends up in the right places. So there's always going to be usually some communication going on between the parties after closing, and it's important to document the expectations in the purchase agreement for this kind of thing. So good healthcare counsel can help you work through that. Let's go to the next slide. Keep in mind, many of these transactions involve restrictive covenants, and by that I mean non-competition provisions. Sometimes they're to protect the buyer. They'll want the seller to agree not to compete with them and not to take employees. And some protect the seller or their reputation. Covenants concerning the business's employees, terminations, pay, or severance. These are commonly the subject of disputes between parties if they're not honored. I do see people sue to enforce these. Generally, those are suits to pursue injunctions to enforce non-competes. Injunctions are an order from a court to comply, essentially. And if you don't comply, then bad things can happen. Generally heavy financial, if the buyer can prove that your violation of a restrictive covenant caused them damage, then you can be, exposed to financial liability. It's really important these covenants are reviewed by an attorney. Non-compete agreements specifically usually have to be limited by scope, in the scope of the geography that's covered, the time period, and the specific activity that's the subject of the non-compete. I'm sure you may have seen some communications that one of our fine federal agencies is trying to really limit the use of non-competes. That is more focused on non-competes in the employment arena as opposed to non-competes in transactional settings. From what I've read and reviewed, it is not going to eliminate non-competes in transactions. So something to keep in mind. It may protect employees from having to sign non-competes with their employers, but it is not going to eliminate non-competes in transactions like this. Let's go to the next slide. Home health and hospice deals sometimes include post-closing purchase price adjustments or updated valuations of the business or sharing of accounts receivable that existed on the closing date. Your purchase agreement needs to define how accounts receivable would be split with specificity. This can be a huge issue if it's not you don't set the ground rules in the purchase agreement and help everybody understand how the process will work. Buyers often want purchase price adjustments to discourage sellers from letting a business fall apart during transaction negotiations or while waiting for closing. Sometimes they want to build in a condition to closing that your census stays above a certain level or your EBITDA stays above a certain level, depending on how long that time period is between the letter of intent and closing. But buyers are taking it on faith that the seller's going to keep running the business, and it's going to be the same when you get to closing that it was when they negotiated for the purchase. So that's just something to keep in mind. Very, very important, last bullet, you got to file all your change of info or change of ownership applications timely, both with licensing and with Medicare and Medicaid. For Medicare, you generally have 30 days after closing to do this. Many state agencies want you to at least notify them before you sign a document, depending on the form of transaction. I know in Louisiana, the Department of Health is a little flexible, but not that flexible. So you really do, depending on what kind of transaction it is, you have to plan for these regulatory notices, whether they need to be delivered before you sign a closing document or if you can deliver them after you sign a closing document. Let's go to the next slide. I've already mentioned some of these special issues for home health, the 36-month rule for home health, which basically says you can't have a change in majority ownership of a home health agency more often than every 36 months. That is going to be applied to hospices if the final reg is promulgated later this year. I mentioned that hospices with an asset sale or with 100% equity sale are now subject to enhanced oversight by CMS. This is already in place as of the end of July. Generally, what this is going to mean is if you have a hospice asset sale or 100% equity sale, they're going to put the agency on prepayment review for some period of time after closing. The MAC will send a letter to the buyer entity, to the provider agency. This prepayment review can be as short as 30 days or it could be as long as a year. And you're still subject to all the other kind of auditing and oversight activities that CMS can impose as well. So this can end up being an interesting scenario for buyers. I haven't had a deal where this has happened yet. It just came out. It just went into effect a little less than 30 days ago. So I haven't closed a hospice sale since this, and I haven't heard from buyers yet about whether they're getting these letters yet, but I would expect this is going to start happening. Often buyers want to manage while waiting for the 36-month restriction to run out if there's some time lag or while waiting for closing to happen. If that's the case, then you're going to want to build that into your overall deal and enter into some kind of interim management agreement. Always, always, always review payer contracts, especially if you're doing an asset deal, to make sure you understand whether you need consent to assignment or not. Assignment means that you're transferring a contract from the seller to the buyer, and this really is only a big issue in asset deals, but payers can refuse to assign contracts. And so it's something that we have to think about whether we're representing a seller or representing a buyer as we negotiate the deal itself. Think about what staff you'll retain if you're a buyer. They're very key to retaining patients, and they're very key to retaining employees. Sometimes if, one of the higher level management folks says, listen, I don't want to go work for that buyer, it can really affect staff retention for your clinical staff or even your administrative staff. So it's, staffing ends up being, I've seen deals fall apart because buyers and sellers couldn't get on the same page about who the buyer was going to keep around. It happens. So something to keep in mind. Don't forget about notifying your accrediting body. If you're an accredited agency, generally speaking, the accreditation will stay with the provider entity. So whether it's an asset deal or an equity deal, that accreditation sort of transfers, but you have to tell them about it. Buyers should be looking at sellers' compliance plans, policies, and procedures, and any audits that have been conducted, whether those were internal or external. And obviously in these deals, buyers are always looking at cost saving strategies. How can they remove redundancies and streamline technical and administrative systems, or improve outreach and marketing efforts, or just streamline internal operations? buyers are really trying, you got to understand, is this the right deal for you? Is it a good deal for you? Are you going to get value out of this? So let's go to the next slide. So in conclusion, transactions are complicated. They can take time, but it's one of my favorite parts of my practice is helping people buy and sell these businesses. Whether you're buying or selling, always make sure the target business continues to operate in its customary manner while negotiations are pending. Understand and be aware of fraud and abuse issues that can crop up, and make sure your counsel is aware of them so that they properly structure things. Feel free and do leverage professionals to handle transactions.
Jennifer? So let me see if, yeah, that is the last slide. So let me just finish up a little thing that she said. And negotiations, including lawyers, appraisers, and accountants, be aware of the long-term risk allocation issues that go on long after the closing. So sorry for all the technical difficulties. Maybe the weather isn't looking great on her side. But thank you so much to our presenter, Jennifer, for that information. And thank you to our attendees for joining us today. I will be sending a copy of the PowerPoint slides tomorrow or today. But if you have any other further questions, please reach out to Jennifer or Heidi. The phone numbers and emails are up above if you want to take a look at it. And have a great Tuesday.